I'm not a lawyer. I'm not even in the law school. So I'm very grateful to be invited. Now, on the question of crisis, it might be a projection on my part of a very severe attack of back pain. But I would lead to if not the word crisis, flux. Because I think if the system wasn't in flux, we wouldn't probably be having the conference at all. And when I think of flux, it's mainly Europe. In 2012, I was doing some interviewing in Brussels, and about CETA's Chapter 11, the woman who was doing the foreign direct investment questions was a really tough neoliberal. We have to have a tough treaty. Germany's breathing down our back because Germany's mad at having lost its competence for investment treaty negotiation. So we are standing firm. 3 years later, Europe is in flux. Germany, of all countries, is leading the discussions about reform. So I think it's a very well-timed panel. The panel, however, has unusual characteristic. 3 of the paper writers are not here. So only Professor Nagy has actually not just written the paper, but will present it. So we're very grateful that, excuse me, that Julie Maupin is going to present the European Union paper by Reinisch, and Andreas Ziegler will present his colleague's paper on Germany, and Armand is going to introduce the Spanish paper briefly. Last thing, I'd like to be very strict with the timing. The first panel was terrific because I think if there are few paper writers, we can encourage more, not just questions, but comments. So do feel free, even if it's not a specific question, to comment. So with that, let's start with Julie Maupin on the European Union paper.
Thank you very much. It's a pleasure to be here today. I apologize that you get me instead of August, but I will do my best to represent his views as he presented them in the paper that he submitted. And I actually did have an opportunity to trade emails with him last week. Some of you may have been following the headlines that there was just last week, hot off the presses, a proposal from the European Commission to actually completely overturn the whole apple cart and set up an investment court for the TTIP. So I'm going to, with August's permission and blessing, say a few things about that as well. So first, I apologize that you don't get it from the horse's mouth himself, but the good thing is he's not here, so if I misrepresent him, he'll never know. Okay, so August, as is typically his style, set out a very lucid summary of the development of international investment policy in the European Union since 2009, when the Union acquired competence to negotiate investment treaties on behalf of the Union, rather than that being done, as in the past, by the individual member states. So, first point that he makes, the early EU involvement in the investment treaty regime has been quite extensive. The Europeans were the first to start signing bilateral investment treaties in the 1959. In the 1960s, actually, 2 countries, Italy and the Netherlands, were the first to include investor-state arbitration in investment treaties. And as we heard earlier, the US and Canada were much later getting into this space. So, very extensive experience. The member states have about 1,400 bilateral investment treaties outstanding. Many of them, I don't remember the exact number, but some 350 or so are intra-EU bits or agreements that have, in some way, shape, or form, different member states implicated. And they have been doing this, as I said, since 1959. They also have regional experience in Europe with the Energy Charter Treaty, to which both the European Union as a union and also the individual member states are parties. So they do have some experience with this mixed capacity of European Union and member state respondent capacity. In 2009, after the Lisbon Treaty was passed and the European Union gained the competence to negotiate investment treaties on behalf of the Union, there were three major questions about that competence that arose. First, does the competence include only portfolio investment, only foreign direct investment, or also portfolio investment? There is currently a case pending before the Court of Justice of the European Union over the EEC competence, particularly pertaining to the EU-Singapore Treaty, which will clarify this. Most commentators expect this to be resolved in favor of the Union, so that in fact it will be decided that the EC does have competence to do this. The second question that arose after the Lisbon Treaty was whether the competence of the European Union was so-called exclusive or mixed competence. The European Commission, not surprisingly, says it's an exclusive competence, and some of the member states said it's a mixed competence. Now, what does this mean as a question of European law? Under European Union law, under the treaties, if the competence is mixed, then once the Union has negotiated and concluded an investment treaty text with some negotiating partner, then the treaty must be ratified, adopted not only by the European Parliament and the Council, but also ratified by the parliaments of the individual member states, so that they retain a residual right to reject the treaty, which obviously makes it much more difficult to conclude a treaty. If it's not mixed competence, if it's exclusive competence, then the European Union can go ahead and negotiate the treaty. And then in terms of adopting it, what needs to happen is that because this is subject to the special unanimity requirement of the European Union's treaties, all of the Council members will have to provide their assent in the form of the European Council, and then the Parliament has to adopt it, the European Parliament, by a majority. So you skip the member state ratification process. This question has not yet been referred to the current Court of Justice of the European Union. I don't know if it will be. Maybe. August thinks that it's possible. If it is, probably most likely, again, the court would come down on the side of the Commission, is what most of the European Union observers think. So exclusive competence and not mixed. Lastly, does it have authority to include investor-state dispute settlement in European-wide treaties? Now, this is contentious in the European Union mainly because the Court of Justice of the European Union is a very zealous guardian of its own jurisdiction and is very concerned about making sure that it has the last word on all questions of European Union law. And there is a fear, which stems out of, in large part, some of the Eastern European cases that we'll hear about in a few minutes, that European Union law could be misinterpreted by investor-state arbitral tribunals, and that the Court of Justice would then not have an opportunity to correct those incorrect interpretations of European Union law, and they would become binding on the European Union without that possibility to correct. Most commentators, again, think that it is inherent in the Lisbon Treaty competence that the European Union can, in fact, include ISDS in investment treaties that it concludes. However, experience shows from the Court of Justice's aversion to other cases, the European Patent Court, for example, and it also in the judgment concerning the accession of the European Union to the European Court of Human Rights, the European Commission would be very wise to make sure that however it does include investor-state dispute settlement in its future treaties, that there is no possibility that EU law is in some way breached or that final interpretations are made about EU law. Okay, the evolving EU approach. The Council, the EU equivocated for a long time after it acquired this competence in 2009. There was a lot of speculation, what direction will it go? The Council came out in favor quite early of investor-state dispute settlement and actually explicitly mandated that the Commission pursue including investor-state dispute settlement in the negotiations with Singapore, Canada, India, China, and Myanmar. The Parliament was initially strongly averse to the idea of ISDS and has lately become more nuanced. It now seems willing to consider some form of investor-state dispute settlement in some agreements, but it has made very clear that the right to regulate of the member states and the European Union has to be very carefully safeguarded, and that it might not be appropriate to have ISDS in all agreements, maybe just some. The public debate on investor-state arbitration within the member states has been extremely high intensity where I sit in Germany, and also in Austria, as well as France. This has been spurred by some very high-profile cases challenging things like the phase out of nuclear energy in Germany, the Philip Morris case that we heard about earlier, the Lone Pine fracking case here in Canada. These things have really caused the public to stand up and say, wait a minute, what's going on here? And it's an extremely well-organized civil society resistance to investor-state arbitration. In mid-2014, the German Federal Council explicitly rejected investor-state arbitration for the TTIP. And because of this special unanimity requirement that the European Union is subject to, if Germany rejects it, the whole thing is dead. So this is a very tricky situation for the Commission to be in. It has to make sure that whatever proposal it puts forth, it has to be able to get the buy-in of the Council, which means all of the individual member states and the Parliament. Most of the criticisms that have emerged in the public debate in Europe, I'd have to say, track very closely a lot of the criticisms that emerged here in Canada and the United States concerning NAFTA. And by and large, August in his paper dismisses these as no longer valid after the evolutions that have been incorporated into the CETA text, tightening substantive treaty standards and the like. So he mentions, I encourage you to read his paper. He very succinctly summarizes the various improvements that have been made over previous treaties that are contained in the CETA, the Canada-EU trade agreement, one of which is to tie FET, the Fair and Equitable Treatment Standard, to make it a closed list. Also, there's a right to regulate clause. There are limitations on the MFN clause. It's been really significantly tightened in the text. He mentions briefly an appellate mechanism discussion, which is maybe no longer relevant in light of the EU's new proposal. So I just want to conclude with a couple of comments about the proposal that came out on September 16th from the European Commission. Now, this was really quite surprising, not in the sense that the Commission has proposed this, because there's been discussion in Europe, and particularly in Germany, for several years, which we also see in Marc Bungenberg's paper, about the possibility of creating a standing investment court. And indeed, a Canadian academic, Gus Van Harten, had proposed such a thing in 2007, so this is not a new discussion. What is new is the European Union showing interest in potentially actually doing it. And not only did they say, hey, maybe we think we would do this, they actually came out with a complete negotiating draft text, which has the provisions on how the judges would be appointed, what kind of jurisdiction they would have, their ethics obligations. It's very, very detailed. I spent quite a few hours going through it, and it has some very interesting innovations that I hope we can talk about maybe later on in today's question and answer session. But just a couple of brief points on what this is. So they've proposed a standing investment court in two divisions. One would be a tribunal of first instance, known as the Investment Tribunal, and this would consist of 15 publicly appointed judges, five from the US, 5 from the EU, and 5 from third countries that are not part of the TTIP arrangement. And the presiding member, they would sit in panels of 3, like with the WTO dispute settlement body, and the presiding member of the tribunal would always have to be one of these third country nationals. And then there's an appeal tribunal as well, which would be composed of 6 sitting judges, 2 EU, 2 US, and 2 of third countries, and again, would always be presided over by the by the neutral party. Yes, so they've imposed very strict time limits, very strict appointment rules and different kinds of criteria, and interestingly have clarified a number of things that very much track the way that the WTO operates, with a little bit of inspiration drawn from the Iran-US Claims Tribunal, interestingly. So this is a very interesting space to watch, and we'll see what happens. The reaction in Germany so far has been quite positive. There have been blog posts on the constitutional blog and things like this that have been happy about this development, but criticizing it still for not going too far. The idea being that it's great if we set up a standing investment court. However, this still means that in TTIP, only the concerns of the investor are actionable, and not the labor rights protections, not the environmental rights protections, not the human rights protections, and various other concerns. So we need to find a way to make sure that there's an effective forum for all of those different stakeholders within the European system. So I'll leave it there. Thanks.
Well, I think there's no introductions. I introduce myself. My name is Andreas Ziegler, and I'm presenting Marc Bungenberg's paper. Now, as being a professor, of course, I couldn't resist the temptation to change it a little bit. A, because I thought Marc and I work a lot together, so he wouldn't mind. B, because we've just been talking about the EU, and basically, of course, a lot of things that you heard are driven by the discussion in Germany, so we don't have to repeat that. And so I thought it might be more interesting for you to get a flavor of what's maybe happening in these countries, among which I would also include Switzerland, or maybe the Netherlands, who for a long time, of course, have been leading almost in this field, at least when it comes to the conclusion of agreements, and who now, of course, are also facing these challenges. This way. No. Yeah. So I have the first part on the past, and the past I would say is very short, but approximately until 1995-2000 to see where we come from, and then the more recent reactions, if recent can be called the last 15 years, what has really happened, and this shall look the following. There are books, of course, and as we're in Canada, I thought I could present you a French publication here, actually from the University of Lausanne. Everything about treaty practice and current developments with regard to Switzerland, for example, is this book here available in French. It's a thesis that was written under my supervision in 2012. That is also something new that had never been done before. There is certainly more scientific interest also in Germany and Switzerland. Now, what has happened since the early 1980s? This doesn't look exactly as it's supposed to, but I can still do that. Now, it has already been said, first Germany, but then quickly also Switzerland, the Netherlands, have been negotiating investment treaties for a while. Investor-state dispute settlement has been included a bit later. This was also already mentioned. Switzerland and Germany more or less introduced it at the same time. These provisions that were traditionally in the typical agreements by these countries would be considered today relatively strong, with some compromises. That's also interesting to look at, but all that is now no longer so relevant. German investors have made use of these provisions from approximately the 1990s, at least when it comes to known cases. Some of them are classics, Saar Papier or Sedlmayr. Swiss investors, when it comes again to known cases, were slower, as it's often the case. Maybe this has probably to do with the fact that they were normally trying to avoid open confrontation. But the first known case that you find in the databases is actually from 1999, but then it really starts only after 2000. Now, what has happened more recently? There is an increase in reactions, of course, also in both countries, Germany, Switzerland. I would say generally in the early 2000s, the debate, be it in academia, be it in the media, be it among politicians, was relatively slow. In academia, certainly NAFTA and so has triggered the development of more courses and more articles, and you may know many of the German contributors in this field. But for example, the press and politicians were really not interested in this for a very long time. The BITs, so government, I was myself negotiating until about 2003, and I'm still in contact with the negotiators now. They were rather slow in adjusting, often fearing that some of the new things that were being done were not yet tested. Especially in Switzerland, again, it's this attitude, maybe let's wait and see. This is something that is in progress, so why should we too quickly change it? So we certainly did not want to take the lead. And when it comes to Germany, I would say for the domestic BITs, that was the same. And now, of course, the discussion basically takes place at the EU level. The perception and the reaction to ISDS has certainly changed a lot with the first cases. And so the first case against Germany, or the known case here, was already mentioned, the Vattenfall case. This now made that NGOs were more interested, and then, of course, automatically also politicians from 2009 onwards. In Switzerland, it took longer, and you can really see that then, this is why it's interesting to compare these countries. As long as you have no case against the state, it is difficult to convince politicians that this is something that should be discussed. And also journalists are usually then not willing to do anything. In Switzerland, we had the first case only this year, 2015, and it changed immediately. So that, of course, then was triggered an interest. And I'll come back to that in a moment. TTIP, of course, makes a major difference. CETA already a little bit before, but I think in the public perception, and we've discussed that also with Armand, it was really TTIP that then made it interesting to talk about this, and we've just heard that. What we also have had already for a while were, of course, appeals before domestic courts. Against UNCITRAL decisions, more in Switzerland than in Germany, Switzerland being a traditional country for the seat of such tribunals. But there also it's interesting, while the Federal Tribunal has issued a number of interesting decisions that you find in the databases, there was really no discussion about this among journalists, politicians, and not even most lawyers, because it was seen as a rather exotic field still. The cases by proper investors, there we have, in the last 15 years now, quite a good use, or good in the sense of intensive use, made by investors. In Germany, you can see that in the paper, Marc counted about 45 cases that he knew. In Switzerland, there are less. Here, nevertheless, there were prominent cases. I think Swiss investors starting to use it, there the SGS cases of the early 2000s made it probably more prominent that this could also be used by local investors. And then, of course, what is most interesting maybe, and where there is most attention paid to, this is multinational companies based in these countries, in particular again in Switzerland. The Philip Morris case against Uruguay is a case under a Swiss BIT. And so you would think, or you could think, that this would be discussed domestically. It is hardly discussed. So here again, it seems politicians are not interested because they usually don't see it. It's not on their radar. The journalists don't seem to find it sufficiently interesting. And some NGOs are talking a little bit about it, but then it's more part of the general debate about multinationals using certain countries for tax and other reasons, and whether that is a legitimate practice to be a host state. And so I've not seen a lot about investor-state dispute settlement being used by multinational companies. Which I find relatively interesting. Media, I've already mentioned. Marc in his paper shows that in the last 2 years, but it's really only with TTIP, that then leading papers like die Süddeutsche Zeitung or die Zeit also talked about this, and usually negatively. For Switzerland, again, most newspapers would not report on this. The leading economic newspaper, die Neue Zürcher Zeitung, has now one journalist that has discovered this and so is reporting about it. But here again, if you talk to them, they say, but we cannot bring too many stories about this. Our readers don't read this. This is too dry. So we need a specific purpose why we do that. Radio, I was recently invited for the first time to talk about this, and the journalists constantly told me, but you must be aware, although this was a cultural program in the most subsidized station we have, they will not know much about it, so please keep it simple, don't go into details. Sorry. And now, it makes, of course, now a difference whether you're an EU member or not. This has been just shown in the discussion of the EU. In Germany, the fact that we have TTIP has really triggered a different debate than, I think, for example, in Switzerland. The fact that there are intra-EU agreements and that this is controversial has a major impact. This is also something where you can nicely compare. This is not an issue in Switzerland. The role of the EU in negotiations. I mean, in Germany, this is mostly also a discussion as to what shall we lose if the Commission takes over. We have to be careful. In Switzerland, we have had EFTA negotiating these things, but again, hardly any attention being paid. Most of the reaction comes really, and I think we've seen that elsewhere, to when there are cases brought against the state. Then all of a sudden, of course, the journalists that I like to talk about, they now see a story. We have seen that with the Vattenfall cases in Germany. We have seen it in Switzerland with the Uzan family case, which is a strange case, but at least it triggered this debate. And just as last additions, what I find interesting in the reaction to ISDS, apart from the general discussion we talked about, is the use of lawyers. So who are the lawyers being used? There is a certain discussion among lawyers, among academics. Shall these states, should they use their own lawyers? Should they use multinational law firms which have a local presence, for example, in Germany? Should they use local companies? Here an interesting incident was that Switzerland, when it faced its first case, they had several scandals with regard to public procurement. So the first thing they did is they put out a notice that they were looking for a law firm and that there was a budget under public procurement rules to defend them in this case. And that triggered then the whole debate on ISDS, but really at a very superficial level. There is now, nevertheless, Swiss law firms, for example, like German law firms, are increasingly interested in this. One of the most recent cases, Alpiq versus Romania. There you have now one of the major economic law firms in Switzerland that's doing this. And so it becomes more normal also here. Maybe the last thing, because we have to finish, this is a moving target, so if you're interested in updates on this, I've put on here a few links, because it's really changing constantly, and especially the media coverage and the political debate is sometimes difficult to keep track of if you're not in the country. Thank you.
Well, I'd like to thank the presenters of the papers for those excellent interpretations. But now we have the actual real thing, and I thought we should award Professor Nagy an extra 3 minutes, so he'll have 15 minutes.
Thank you very much for your kind words and the introduction. And my name is Csongor István Nagy, and I'm presenting the paper of Csongor István Nagy. That's my specialty for today. Of course, I would be very happy to say that I crossed the big ocean to be here and I traveled for a long time. But actually, for this academic year, I'm residing in Indiana, Bloomington, so it was it was very easy to get here, actually, so it was not a long journey. I will be speaking about Central European perspectives of investor-state arbitration. Central European states have a couple of common features, and they have a lot of differences. So this is not a uniform region. So that is why it's not easy to put this together and to treat this as one uniform area. But there are some common features in the region, and I would like to speak about these, and then to give you an overview on the experiences of Central European states, which are the new member states of those member states which joined the European Union in the last 3 waves of EU enlargement. So what we have here are, these are states in between, because these are states which experienced the transition from a planned economy to a market economy. Of course, this was 25 years ago, so it's very much history, so we cannot say that this is the actual status of these states, but still these old years have some reminiscences in Central Europe, and this appears in the grasp of the role of the state in the market. So in these states, people, citizens, expect the state to be more interventionist in market processes, so price regulation, state intervention, and state monopolies are more important or more significant than other parts of Europe. So this is one of the specialty. Rule of law issues emerge in investor-state or arbitration cases. So as I said, these states are in a transition zone, so not all traditional Western democracies, but still not developing countries. And the trust in legal procedures is somewhat lower than in the western part of Europe. At least, of course, it doesn't matter what you do in politics and in public life. What really matters how you appear in the public sphere. And if I'm saying that the trust in legal procedures is lower, it really doesn't matter what the reality is. This is what is perceived by investors, and this is what's addressed in the procedures. And another very interesting set of rules are intra-EU disputes, which were mentioned but not covered in the previous presentations. I will come back to this, but the accession of Central European countries to the European Union brought new issues to the light. The European Union, old member states concluded various bilateral agreements with states, Central European states, which were not part of the European Union at that time. And these were non-intra-EU agreements, because at that time, in the early 90s, these states were not part of the European Union. So Germany concluded agreements with Hungary and Poland. These were not intra-EU member states. But as the EU was enlarged from one day to another, so overnight, these became intra-EU agreements. Intra-EU agreements between before the accession of the Central European countries were not present in reality. Theoretically, there were some agreements, but they were never applied. So this created a new problem of interpretation. I will come back to this. So I will address the treaty landscape, so how, from a policy perspective, these states react to investor-state arbitration. I will give you an overview on the intra-EU matters and the problems, and I will share with you some experiences of Central European states case law. So what is the treaty landscape? It's a very boring area in the sense that, with some exceptions, all states follow the same standard pattern. They are members of the ICSID Convention. They are parties to the ICSID Convention, and they have pretty much standard bilateral BIT, so bilateral agreements. So there are no huge differences as to other parts of the world. There are numerous ad hoc arbitral tribunal cases, but this depends on the country. So for instance, Hungary, the Hungarian cases were tried before ICSID tribunals, almost all of them. But if you take a look at the Czech Republic, the vast majority, almost all of the cases were tried by ad hoc tribunals. So this is a very diverse picture. There are two mavericks in the region, and I'm speaking about more than 10 states, so this is a small minority. We have Poland, which is not a party to the ICSID Convention. We don't know why, but anecdotal evidence suggests that the reason is the following. Under the ICSID Convention, if you have an ICSID award, it cannot be reviewed, it cannot be, recognition and enforcement cannot be rejected with reference to local public policy. And this is unacceptable for Poland, so they use the New York Convention to have these awards recognized and enforced, because there you can refer to local public policy. But they didn't want to give up public policy defense. So that's one of the issues. Hungary is part of the standard framework, so a member of the ICSID Convention. However, Hungary adopted a set of idiosyncratic rules according to which state entities cannot stipulate arbitration in matters involving public assets or state property or national property. Now, basically, this covers commercial arbitration and investment arbitration, so it just has a general scope and purview. The Hungarian Constitutional Court said that these rules cannot have retrospective effects, so they have nothing to do with the existing BITs, they have nothing to do with existing agreements, but the practical effect is that Hungary, according to these rules, will not be able to conclude new BITs except it amends its own law. But this is a domestic issue and a domestic regulation, and of course the Parliament can amend this law at any time. So these are the two mavericks, but generally we have a relatively uniform landscape. Now, what is the experience in the region on investor-state arbitration? So what are the perceptions? The vast majority of the cases are so-called treatment cases. So no genuine expropriation cases, not even regulatory or indirect expropriation. So I'm speaking about cases which are tried under the fair and equitable treatment clause of the applicable BIT. Of course, expropriation is raised as an argument all the time, because of course, if you are there, why not to raise it? But I'm saying that there are no genuine expropriation cases. I mean that although the argument is raised, but it's rejected outright, or it's unfounded, or the arguments as to expropriation are ridiculous, and the core issues are fair and equitable treatment. And the reasons are mainly the following. The first one has already been mentioned. State intervention can be very, very stifling in the region because on the side of the society there is a huge expectation towards the state to regulate the market, to intervene, to provide public services, and so on. So this is the grasp of the role of the state. In some cases, because of the rejection of further privatization, procedures were started, let's say against Poland. And a very significant part of the cases deals with the review of national legal procedures. So administrative procedures, customs authority procedures, revenue service procedures, court procedures, civil law disputes, purely civil law disputes, or public tenders. Public tenders are legally regulated in the member states, so this is why I'm saying that these are legal procedures as well, because you have a remedy under national law in case there's some problem with the public tender. So the majority of the cases deal with issues like this, and the significant part of these deal with the review of these procedures. So these are mainly about due process, fair trial. And another experience is that in 99 or 95% of the cases, the claimant fails and the judgment is entered for the respondent, so the states win. Arbitral tribunals are extremely deferential in these treatment cases. So actually, I will put together a statistic for the revised version of the paper, but it's like, I'm saying that it's not, I can say that in less than 10% of the cases can the respondents win, sorry, the claimants win under the treatment provisions. So actually the respondents are very, very successful, and the tribunals are not really taking up these cases. Now what's the problem with this? First, if you get a trial, you can get very scared, and that's, this has some psychological implications in these countries. And there's another problem. These are the legal costs. It's not very much spelled out, but these are small states. I mean, Poland is not a small state, but you have the Baltic states, you have Hungary, Slovakia, states of 3, 5, 6, 7, 8, 10 million people, inhabitants. And if you compare the legal cost of these proceedings to the annual budget of this state, then the costs can be huge. These are not prohibitive, so it never happens that the state is not defended before an arbitral tribunal because of cost reasons. I have anecdotal evidence on this concerning states from the Middle East when they said that it would enter settlement because the proceeding would be too expensive. But this is not a problem in the region, but still it's an issue, because if you made a comparison, if you compare, for instance, Hungary's legal costs in King City, Vigotop, the judgment was entered this year, I think, adopted this year. Hungary had costs in value of approximately $9 million. Well, if you compare this to the budget of the Hungarian Ministry of Justice, this is not the this doesn't cover the fees of external experts, but these are the full budget of the ministry. It's $50-60 million, and if you compare this to the management costs of the central ministry, because the 50-60 million also covers different local organs which are supervised by the ministry. But if you cover only the management cost of the headquarters, it is around $8-10 million. So actually, it's the expenses of the annual expenses of the central institution of the Hungarian Ministry of Justice are comparable to the legal costs in this one particular case. Now, well, of course, these costs were seriously cut. So before the financial crisis, this was like 60 million. But even in that case, if you compare the two figures, you see that something is not in balance. There shouldn't be a problem in itself, because we say that, as the saying goes, the winner takes it all, the loser has to fall. So the winner should take the whole benefit, and if Hungary wins the case as a respondent, well, of course, the cost should be shifted on the plaintiff, and the tribunals have this possibility. But in the vast majority of the cases, they don't use this. So actually, as a matter of practice, the tribunals, and this is the perception, follow the American rule in these trials, proceedings, litigation, in these arbitral proceedings. So the respondent state, wins the treatment case in 90% of the matters, but ends up in paying out the lawyers, which is of course a good news for lawyers, including myself. But this is not fair. This is the perception in the region. So this is an issue, I think. And the third point is intra-EU bilateral investment treaties. I will skip some parts of this story. I'll just give you describe to you what kind of vicious circle can these agreements cause. So we have the bilateral investment treaty, which says something. You have EU law, which says something else. EU law says that you shouldn't give state aid subsidies to enterprises as a general rule. And member states, after joining the European Union, withdrew some subsidies they withdrew some measures which contained subsidies in order to comply with the European Union law. So for instance, they were tax benefits, tax allowances, or they were contracts concluded with electricity companies which secured a certain price for these companies. And the Commission said, well, this is contrary to state aid law, you are subsidizing these companies, withdraw the benefit. And states withdrew the benefit, they revoked the benefit, and they were sued before investment tribunals. And some of them lost, and the investment tribunal said that if you promise a tax benefit, then you cannot withdraw it because you promised it for 10 years. I don't care about EU law. If you promised it, this is unfair treatment. Okay, last sentence. So what happened, and I'm just pointing to the last case, in Mikula Brothers, the tribunal said, pay compensation for the state aid you withdrew. The Commission said, don't do that, because that's a replacement for the state aid. So actually, this is a substitute of the state aid. So there are two conflicting obligations, one from the Commission, the other one from the tribunal. We don't know what will happen because the case is pending before the General Court. And just to scroll it down. Thank you very much for your attention.
Well, we have 18 minutes, so please just ask your questions or make your comments and the panel will respond. Oh, sorry, Armand. Sorry. So we're here from Spain, a very, very interesting country on this issue.
I'll be very brief. Reporting for Professor Otero García-Castrillón, who can't be with us today. She has a paper on a number of very interesting cases. Spain quite suddenly finds itself the object of some 20 investor-state claims, I think largely under the Energy Treaty, but also under some of the bilaterals. These all result from what may have been an unwise policy of the Spanish government beginning in 2005, partly in response to EU policies, that they would subsidize the additional cost of non-traditional electricity from solar and wind, etc. And so these policies were put in place. The government offered to subsidize, and foreign investors came in, built their plants, and then 2008, 2009, 2010 struck. Spanish government, of course, faced terrible economic difficulties and had to reconsider its position, and among other things, simply said to these companies, sorry, we have to cut these subsidies. We will no longer subsidize the difference between the market rate and whatever your cost may be. The company's first instance, and this is interesting, and I think it goes to something that's already been discussed, the company's first line of attack was to go to domestic courts. Where they have lost hands down. They've been told you have no guarantee that these subsidies will remain forever. You have no legitimate expectations that these subsidies will remain forever. And in any case, your government faced a legitimate and very serious crisis, economic crisis, and had to respond and responded responsibly. Therefore, they have lost before the courts, and now they have turned to investor-state arbitration. Presumably, the basic argument must be that the courts have treated them unfairly, and my thought is that's probably going to be a very difficult argument to sustain. But I simply am reporting to you. I think you should read the paper, and I won't take further time, but it does raise this very dramatic question. You've gone through the courts, the complainants have gone through the courts, lost, and now they attempt to make it into an investor-state issue. I'll leave it at that.
Now the floor is open.
My name is Peter Mazur. I'm a reporter for Embassy Newspaper. I have a question. It's sort of a forward-looking question, so I'm not sure how much you'll be able to speculate about it. But with the European Commission's recent proposal to bring in a separate tribunal system for dealing with these sorts of complaints, we're facing the prospect of having a trade agreement between the EU and the United States with one way of dealing with these cases, and an agreement between the EU and Canada with sort of the more traditional ISDS provisions that have so far been sort of agreed upon. What could be the practical differences if that were the case for companies taking up complaints, say American companies taking up these sorts of cases in Europe versus Canadian companies that are trying to do a similar thing? And given the fact that most Canadian companies that operate in Europe also do so in the United States, what do you expect to be the practical realities for these companies that are deciding how to go about taking their claims up in Europe?
I think it's very difficult to have a crystal ball in that regard. One point that I should emphasize with respect to the Commission's proposal is that it's actually quite explicit in that the goal of the Commission is to eventually move towards an entire world in which we have no investor-state arbitration, but only an investment court system. So it's quite explicitly stated that they will seek to go back and renegotiate previous agreements that have been concluded in the past to replace whatever investor-state arbitration system there is with, to fold it into the new investment court model. So while it would start just with TTIP, it would eventually encompass probably CETA as well, the Canadian agreement. In the meantime, what kinds of implications does that have for investors? Obviously, it makes it quite tricky, and it raises questions about the efficacy of the regime in terms of genuinely providing a level playing field, which is one of the strongest justifications that has been given in the past for investment treaties generally. If you have a different type of court resolution system under one agreement than under the other, you still run the risk that you are going to end up with differently interpreted standards across the two systems, even if the standards themselves are identical, just because the people doing the interpreting are doing it differently. And particularly because the TTIP proposal has an appellate body within it, so that any inconsistencies in interpretation will then eventually be solved and settled with an authoritative interpretation, which we don't have yet in CETA. So practical implications, I think that if the EU really pushes forward with this proposal, and it's now going to enter into a period of consultation with the Parliament and the Council and the member states about this proposal before it formally tables it with the United States. But if it really pushes forward with this proposal, I think that you will also see a delay in the ratification of CETA, because there will be a consideration of whether they don't just go back and renegotiate with the Canadians in order to not have this discrepancy across the two agreements. That would be my guess about their approach. So I don't think that my guess would be we wouldn't end up with two different regimes. And I'm sure David Gantz is about to point out that the US is extremely unlikely to accept this proposal in any event. But.
Actually, I thought I'd save that part for the afternoon discussion. The point I wanted to make was the idea of an analogy between the U.S. Arena Claims Tribunal and this tribunal that comes up in the Commission proposal, and to suggest that there are some similarities in the sense that the governments appointed the essentially three panels of three persons, one Iranian, one US, and one neutral, usually a European, and they kept replacing those as necessary over 25 odd years. But there's some other significant differences. First of all, this was a situation where mostly was driven by $6 billion or so of US claims against Iran, where the claimants really had no alternative since they were not allowed to proceed in US court as part of the hostage settlement. And a situation where, at least on the US side, most of the people who were appointed were very much pro-investor because they were trying to recover from the Iranians. You had some like George Aldrich, who was a legal advisor lawyer, but you had people like Charlie Brower, who, you know, as we all know, is very much pro-investor, and the people that have been appointed over and over again have been in that context. Even now, where the remaining claims are by the Iranian government against the United States based on military equipment that's never decided. You know, one of the most recent appointments is a guy by the name of Tom Johnson, some of you may know, who was at Covington and Burling and was involved in litigating on behalf of a number of the companies. So you've got that very different context involved in this process, and when you look at the U.S. concerns about this proposal, a lot of it is, well, they're only going to appoint people that will find it in favor of the government, which probably isn't true, but that's the kind of language that's being raised. So I think one has to be a little bit careful, even though that's the only tribunal that I'm aware of major scope where the members were all appointed by the governments.
Just to keep the conversation going, wondering if our friends from Europe can tell us whether the proposed court is something that will be attractive to civil society, NGOs. The Greens, I understand, are vocal in their opposition. So what's going to happen at the domestic level in response to this proposal?
Okay, maybe we can talk a bit more about this proposal, also some internal things. The debate is now very much characterized by a proposal made by our colleague Markus Krajewski, who is just one of the few professors in Switzerland, in Germany, who has been working for a while on international economic law, who, like many of us, this is also interesting to see, originally did much more on WTO law, and then in recent years, being again the last 10 years, doing more on investment law. So you can clearly see, I think, in this proposal that it is very much influenced by the experience at the WTO. I think and then of course all the things that happened in recent cases, but the solutions we're looking for often come from there because we have a similar debate. So it comes to transparency, amicus curiae briefs, all these things. I think we have had some of that discussion already. And the NGOs, to the level they enter into this debate, also usually then recycle the discussions we have had there. And so I think, it takes up some of these criticism that has been brought up by these NGOs. There are some also think tanks which have made a kind of a profession out of this, of course, and have found a new area. So many of these things are taken up. So I think it could be, for those who admit that investors' protection is legitimate in the first place, and that there should be some kind of dispute settlement not before domestic courts, that's kind of the starting point, then they will probably jump on this and maybe try to get a bit more. But I think for them it could be the best they can think of to get in this situation. That's my personal assessment.
Well, it's not easy to predict how they would react, but I'm pretty sure that that as compared to ad hoc arbitral tribunal proceedings, much more consistency and transparency could be secured in this way. And I think that the biggest problem with from a Central European perspective, with the treatment cases and the intra-EU matters, that you basically don't know what the tribunal will say and what framework of analysis will be used. I didn't have time to cover the intra-EU matters, and I don't want to use your time just telling you what I couldn't tell in the presentation. But you have conflicting judgments. So you have one case where it is said that EU law prevails over the BIT. You have another case where the tribunal said it depends, and you have a third case where the tribunal, in the very same legal question, said that no, the BIT should prevail over EU law and over EU state aid law. One of my professors, old professors, said that in law it doesn't really matter what you say, but you have to say the same thing all the time. I do not completely agree with that, but I think that this is one of the merits a tribunal or a court or an institution can have, and that would be very, very important. And in the ad hoc system, you cannot really secure this.
So I have time for a quick question to continue on that. The analogy with the WTO dispute settlement system is one aspect of the European proposal that I would like to have more details about is enforcement. A ruling by the dispute settlement body of the WTO is not enforceable before national courts. Arbitral awards are enforceable before national courts. So how does the issue of enforcement is dealt with in the European proposal? Because I think that can be an important aspect of the debate.
That's a very interesting part of the proposal, actually, and this also ties in with David's question. The grounds for referring a decision to the appellate instance tribunal that are set out in the EU's proposal are threefold. First, you have the usual things that appear in the ICSID Convention annulment provision in Article 52, so there was some sort of serious procedural defect like corruption or failure to listen to one of the parties or something like that. Then you have the second ground that you get, though, is that the first instance tribunal got the law wrong, which is different, right? And the law here refers only to the TTIP itself, because then the appellate body is, or the appellate tribunal is the authoritative interpreter of this agreement and therefore has the opportunity to correct incorrect or inconsistent interpretations among the first instance tribunals. So that's the second ground. And then the third ground is very interesting and I think would speak somewhat to some of the concerns of like the Green Party and others who would still be averse to any kind of international dispute resolution for investors. The third ground is that it's stipulated in the text that tribunals are supposed to treat domestic law as an issue of fact. And so if they have to apply some sort of question of domestic law, they have to treat it as fact and they have to look to the case law of the country in question and the highest courts of that country to determine what the law is. So they're not free to just determine for themselves what Canadian law is. They have to look at how Canadian courts have interpreted Canadian law and then treat that as a question of fact. And the third ground for appeal is actually that there was a manifest error in the interpretation of law as fact, domestic law as fact. So to the extent that German environmental law was grossly misrepresented by a tribunal, there would be a possibility then for appeal to the appellate tribunal. Whether that makes the Greens happy or not, I'm not sure. But the draft text then finally, to come to your point, also provides that the arbitral awards of the, well, court awards, I guess there would be, of the whether the first instance tribunal or the appellate body would be enforceable in the same way as final awards under the New York Convention. So they would be then subject to those procedures as well. The EU can't join the ICSID Convention because it's not a state, so this is why they've turned to the New York Convention. And this is another question about will the US accept it, because the US accepts the WTO on the grounds that you don't actually have to pay if you lose a case. You can suspend, you can let the other country retaliate. And sometimes for political reasons, it's better to let the other country retaliate than to actually pay out large cash awards. And that wouldn't exist in this system, so it'll be interesting to see what the US thinks of that.
Okay, thank you very much to all these panelists and to Stephen Clarkson for chairing this panel. We had a great discussion about the EU and this conversation will continue through the lunch and also later on in the afternoon. So thanks very much to Stephen, Julie, Andreas, Csongor, and Armand, as all in their various roles. It's been a great panel. And if the Give them a hand. Thank you.